We are in the Karen Reed multiverse, and we are talking about the wrongful death lawsuit. The O'Keeffes, in kind of different configurations, have sued Karen Reed and the hospitality defendants, the bars, C.F. McCarthy's, and the Waterfall. In the wrongful death case, this one has been ongoing the longest, and the discovery deadline to have everything done closes in August. And so now there is a ramping up of all of the motions to compel. A motion to compel is generally, hey, Your Honor, can you tell them to do this? They won't give me discovery. They won't sit for their deposition. They won't turn over their interrogatories. They won't respond to their requests for productions. They won't give us their documents. They won't give us their document in order. It's not tabbed. It's too many gigabytes. It's not enough gigabytes. It's tetrabytes. I don't know what kind of bytes it is. Can you make them do whatever is your motion to compel? We are going to court for the continuation of the motion to compel Colin Albert's deposition that the court had continued because defense counsel said, we only get to talk to Colin once a week on Saturdays. And the court goes, fine, go figure out what day he's going to be back here for a deposition and then come back to court next week and tell me. And the lawyer said, okay, my colleague will stand in, but I'll be back in court. Fine. Let's fly to Massachusetts.
So our belief is that anything that Mr. Albert may have, any communications or documents that he may have relating to the facts and circumstances of Mr. O'Keeffe's death, or the law enforcement investigation into Mr. O'Keeffe's death, would encompass any responsive material that would be relevant to this matter. And we're willing to do that. We're willing to do that for a 3.5-year period. And we're willing to do it with respect to every individual that they've asked for communications to or from. And so this, to me, is a little bit of a situation where Ms. Reed won't take yes for an answer. We're actually agreeing.
I can see where the concern is. What's a conversation about the investigation versus what's a conversation about where you were? I can see what the concern is. Reed's team wants to make sure that we're not playing games with what are we saying about this night. And this is par for the course with civil. The definitions of everything matter. And one party is going to seek for the broadest possible definition, and the other party is going to seek for the narrowest possible definition.
To provide anything that we may have relating to the facts of John O'Keeffe's death, which is the central issue in this case, or the investigation into his death, which, as I understand it, would encompass what Ms. Reed has claimed is a false narrative surrounding, what the plaintiff would claim is her false narrative surrounding that death. So we are comfortable frankly, that we've kind of bent over backwards to include a 3.5-year time period of two very broad categories. I offered to discuss search terms with counsel that we could agree to in order to come up with materials that might be responsive. And so, for example, if counsel felt that the category we've suggested would not encompass the timing of when Mr. Albert left 34 Fairview, the way around that is just to agree to a search term that would capture those communications, because we have no objection that those would be responsive and within the category we've suggested.
Then why couldn't y'all come to this understanding on Friday?
But what we object to is a unscoped request for materials, particularly relating to communications he may have had with his parents, and the very, very broad categories that seem designed to capture information that is not relevant to the issues in this case, which, as I understand it, are one, the facts and circumstances surrounding Officer O'Keeffe's death.
Hang on.
Yep.
Give him a chance to respond.
Yes, sir.
You think it?
Yeah, I'm actually going to address what I think Mr. Maddie was about to address. This case isn't just about what happened to John O'Keeffe. That's part of the wrongful death claims that the plaintiffs have alleged. But as Your Honor's aware, they have these false narrative, intentional infliction of emotional distress, negligent infliction claims. That includes the investigators, the investigation, and what Ms. Reed said in both her criminal trial and her other statements that something happened to Mr. O'Keeffe within the house. That is the false narrative. So it can't be limited to just the death of John O'Keeffe. I'll give you one example. If Colin Albert had sent a text about Karen Reed but not about the death of John O'Keefe
Or
and
the
specifically the
investigation.
circumstances. I believe that's well within the scope of discovery in this case, and it would be excluded by what Mr. Albert's counsel has proposed. Similarly, if Mr. Albert said something about his relationship with investigators, which is a main part of that quote unquote false narrative in this case, and that Mr. Albert himself is suing Ms. Reed about, that necessarily wouldn't have been included. So it needs to be broader. I'm more than happy to work on search terms with Mr. Albert's counsel. In fact, I think that's a very efficient way to do that. But we need to either agree on, which we haven't been able to, or establish through Your Honor what the scope and the categories that are rightfully at play here are.
And the thing is, everybody's real feisty over email, and then they're in front of the judge, and now they're like, well, we could agree on search terms. And they're like, news to me.
I'm more than happy to work with them on search terms immediately to get to those categories. But I think you can hear that we've still got differences here. And this is not unscoped. You can see we proposed terms. We limited it from the subpoena. There are specific topics that we're asking for, not even of everyone, but only of certain individuals. And those topics are Ms. Reed, Mr. O'Keefe, the investigation, the state police and Canton police, the Norfolk DA, and the U.S. Attorney or DOJ. That's not everything under the sun.
Those are
and to
terms.
the extent there are categories or individuals where Mr. Albert.
And so this is where Karen Reed's team is saying, look, limiting the search to conversations about the investigation doesn't always get us there. So we should broaden that to conversations about Karen Reed, conversations about John O'Keefe, conversations about the investigators, conversations, I think, about the trial, which would encompass Karen Reed. So they're fighting over what discovery they're going to get in document discovery before they even get to a deposition.
That's not everything under the sun. And to the extent there are categories or individuals where Mr. Albert has none, as I've said repeatedly, we will accept that. If counsel represents there were no documents as to, individuals A through D, then we're done with those. And additionally, if there was some extreme burden, right, there was one term or subject matter that was bringing back thousands of messages and it was going to be burdensome in order to go through and produce those, we would have considered that. But we haven't heard any of that in the communications or in the multiple hearings we've now had. It's just this overall, this is too broad. And we heard, Your Honor, about the time scope. We cut it more than in half. We addressed the terms, but at a certain point, we're entitled to the discovery that we're seeking pursuant to our subpoena.
What Ms. Reed apparently wants to present as a defense in the wrongful death case to the emotional distress count is that what she said was in fact true. Or whatever she claims happened.
Or it wasn't negligent. This is lawyer parsing, but I don't think she has to prove necessarily that it's true. I think she has to prove that it wasn't negligent to say it.
With respect to their claim that they should be entitled to any communication about Miss Reed, Mr. Albert was and is a victim in a criminal case that's been brought against Aiden Kearney that, as I understand it, Miss Reed was at one point a subject of as well. She was not charged. But I'm highlighting this as an example of why Mr. Albert might very well have communications about Miss Reed.
You're just trying to stagger when the shit comes out of the horse at this point.
That have nothing to do with the issues in this case. They would want us to produce a communication in which Mr. Albert pointed out that Miss Reed had a dog or a cat, which has no relevance to this case. Or that Miss Reed...
Does Karen Reed have a dog or a cat? Also, what's the problem of turning over Colin Albert saying, well, does she have a dog? Because if it's not relevant to come in at trial, then you fight it then.
Had launched a defamation campaign against him, which also has no relevance to this case. It may have relevance to some other case, but it has no relevance to whether or not Mr. O'Keefe, the circumstances surrounding his death, which again, we agree. So I'm not understanding yet why the very, very broad scope, which I think counsel would acknowledge, would necessarily result in communications that are not relevant to anything here. Why the court should bless something like that when what we've proposed, I think, broadly encompasses all of the claims in this case.
Just 2 quick points. One, the false narrative is not just about the death of John O'Keefe. The part of that alleged false narrative is the cover-up and conspiracy side of things. That necessarily came after Mr. O'Keefe died. So it's inaccurate to say that we can capture anything relevant to this case by stopping on January 29th, 2022 or thereabouts. Secondly, as we're all aware, this is a third-party subpoena. At a certain point, a third party is not in a position with standing to argue about specifics of relevance. They have standing to argue about burden and undue burden on a third party.
That's
and we recognize that, and that's why we made changes. But a relevance objection like this is misplaced at this point. We are entitled to put document requests that, in a subpoena that are reasonably intended to gather relevant topics. I think a term that relates to communications about Karen Reed and about John O'Keefe is well within that scope, as Rule 26 uses the phrase relevance.
Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson, and we've also done some research about how a deposition of an active duty service member would be arranged. And bottom line up front, Mr. Albert,
is he active duty? I don't know when that counts.
And bottom line up front, Mr. Albert, as a trainee in the United States Army, is under the command and control of his commanding officer. And so if Ms. Reed wishes to take his deposition, yes, sir.
Just curious,
Trainee and active duty don't sound like the same thing, but I have questions, so now the court's interjecting.
To take his deposition, yes, sir.
Just curious, did your research include a subpoena that already was served?
Well, Your Honor, so I guess the question you're raising is, if Mr. Albert had been served with a subpoena.
No. Nope. I appreciate your reframing. No. The court decided last week that it was still a valid subpoena based on everything that the court said. Did he expressly rule that? No. But the court, in everything the court discussed last week, the court operatively said that that is a served and still valid subpoena.
Your Honor, so I guess the question you're raising is, if Mr. Albert had been served with a subpoena.
He had been.
Correct. Prior to entering the military. And let's presume for a second that that subpoena remains valid, even though I know you know we take a different position.
The court's already determined that. Emily, keep reading. The court interjected there. If he's been served, the court said he has been.
And he then enters the United States Army in the interim. The United States Army has custody of his person. And so if the deposition is going to take place after the date upon which it was originally scheduled, April 29th, I think, then the only way for that deposition to occur is with the consent of the United States Army. And there's a process for that. What would happen is Attorney Reed's counsel, Miss Reed's counsel, or we could help facilitate this process, would reach out to the staff judge advocate at Fort Jackson and let them know that there is a request for a non-party in civil litigation pending in Massachusetts.
Why is this their problem when he was served before, though?
To take Mr. Albert's deposition. And I've never done that before, so I don't know exactly how that process would play out, but I know that that would be the necessary first step. Now, I've called the staff judge advocate 4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who is a former JAG officer with 2 combat deployments. She advised me that
I appreciate your colleague who was JAG, who had 2 combat deployments, thank them for their service. How does this have anything to do with when Colin Albert's going to be available? Like, yay for co-counsel, but also what does it have to do with the question that the court asked you?
2 combat deployments. She advised me that the process would definitely include the staff judge advocate at Fort Jackson, may also include the Army Litigation Division, which is the main legal component of the United States Army, and that process would just have to play out.
When did you talk to your client?
Neither we nor Mr. Albert have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has very limited access to telephone. His day starts.
This is going to get real messy.
He's not given any leave. He's not given any visitation at Fort Jackson. He has very limited access to telephone. His day starts at 4:30 in the morning, ends at 9 p.m., and it's entirely structured. And the basic combat training program is phased, so that phase 2 builds on phase 1, phase 3 builds on phase 2. This is a 10-week program, after which we understand he will be granted leave. And so what I asked counsel last week was...
Last week it was a 3-week program, then a 10-week program. This week it's a 10-week program. I still don't know.
Listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling order for the sole purpose of conducting this deposition after Mr. Albert completes basic training, and if the other defendants, if the other parties agreed to that, would you? And they said no. And I asked them why, and they said they had strategic reasons. And what it made me wonder is why they...
What are the chances that he watched the hearing where the judge was all mad about the strategic reasons and that's why he's bringing it up? I'm just curious. But what he is saying is that in his conversations with Rosenberg, he asked if the judge will allow for an embiggening or an enlargement of the scheduling order. The scheduling order is the discovery cutoff. Would you allow us to delay Colin Albert's deposition? And he said, no. They said they had strategic reasons. Emily, what could those strategic reasons be? Well, they don't want the witnesses talking to each other. They want to put the depositions in order so that they can follow up on, I imagine they would want to take Colin Albert's deposition before they took his parents' depositions so that they could follow up on it. I wonder if he's bringing this point up specifically. So saying they told us they would not agree because they have strategic reasons. Sure.
Strategic reasons. And what it made me wonder is why they hadn't taken his deposition in the many, many months during which this case has been pending, and why they didn't take his deposition when he actually sat for it 2 weeks ago.
Because they didn't have the documents.
The latter question is they didn't have the documents.
Sorry, Judge. Sorry, Judge G.
Well, the answer to the latter question is they didn't have the documents, and they had said in their discussions with you that they wanted the documents before they took the deposition.
And they don't have the documents now, Judge. And so what I'm saying is, given the burden that this would place on Mr. Albert, and the fact that he's already been...
Excuse me for interrupting, but the burden is self-imposed because there was a subpoena, and as I've said enough...
Oh, shit. Judge G's out. Judge G's done. Judge G's like, you've punched yourself in the face and are like, stop hitting me.
Because there was a subpoena. And as I've said a number of times, a subpoena has to mean something. And there was also some agreement between the attorneys. And the words and actions of an attorney need to mean something too.
Your Honor, let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I've read that.
Here the fuck we go.
I am not aware of any agreement between attorneys. I've read that email traffic. I was not the one negotiating this, but I've read that email traffic. And that deposition was canceled. And if they want to take a deposition of him on a different date, they can issue a subpoena for a different date. But it is my understanding that there was no agreement. I also want to just say one thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to...
Who told him it was canceled, though?
One thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to be available for a deposition in a compressed period of time, and one party decides not to take advantage of that, and then he enlists and subjects himself to basic training, and the idea is that he was supposed to organize his life choices as a non-party witness around when Miss Reed might ultimately decide to take his deposition, I don't think it's fair to suggest that he's imposed this burden on himself. He's undertaking.
Oh, you take issue with how the court framed that, do you?
A burden to serve our country, made himself available for a deposition, and now all we're saying is, under these circumstances, wouldn't it make sense to conduct this particular deposition when the young man has completed his basic training, and after which we've resolved all these issues about documents?
Deposition wasn't canceled, Your Honor. You can read the emails yourself. I'm the one who wrote it. It said the deposition will be rescheduled when we resolve the pending dispute over the documents. Mr. Maddie points out we still don't have the documents. That's because they still haven't agreed to produce the documents, and we need to be back here with Your Honor for a second hearing to get what we believe is a significantly narrowed scope, which we proposed last week after Your Honor provided some feedback on the initial scope. Also, subpoena's not a request. Mr. Maddie said a request that he be deposed. It's not a request. It's a court order. The case law is clear. A subpoena is a court order. And obviously...
No, it's not a request. We're not requesting shit. We're demanding. Right.
We're not looking, as I've said, to impose an unfair burden. We recognized that the service didn't happen in time and immediately said, yeah, that's too tight. We will reschedule it. To now argue that by saying we will reschedule it, which is exactly what the email says, that we canceled the deposition and rendered the subpoena ineffective is, I think, absurd. And it flies in the face of the obligation that a party serving a subpoena has, as Your Honor pointed out, to work with the recipient in order to do it in an efficient way and not impose an undue burden.
Right. And what would have happened if they went ahead with the deposition without the documents and then said, well, we need another deposition. Now we get the documents. What would the argument be then?
I also haven't heard any of this until right now. We've been conferring. I heard that it's difficult, but the specifics of the steps that they've been trying to take, we haven't heard. I would have a couple questions. One, was Mr. Albert asked to identify this?
Hello, Mr. Rosenberg. We also have questions.
Was Mr. Albert asked to identify this proceeding and the subpoena that he had received when he enlisted in the military? If he was, does that impact his ability to come back to Massachusetts to appear pursuant to the subpoena that was issued in this case?
I mean, the question we've all been asking since last week, isn't it?
At the end of the day, everyone here, I think, respects a decision to serve our country, but the timing of this is extremely relevant.
What are the other questions?
We served the deposition, the subpoena. We had the back and forth where we said we would reschedule. We waited 3 weeks for a response on the documents. We got an email that said, in effect, he's available for the next 13 days and then he's gone. That's not appropriate, and that's not in compliance with a subpoena that's issued by counsel through this court.
Our position is they cancel it. Our position is that there is not a valid subpoena to be enforced right now. However, given the importance of working collaboratively with counsel, we are going to continue to do that. And if the court tells us that we need to find a way to pull Colin Albert out of basic training, we will go ahead and see what that process is and pursue it. But I don't think that's fair to him. I really don't. And I don't think Attorney Rosenberg thinks that's fair to him.
It's a bold strategy, counsel. After the email back and forth, and after you're like, I've read this email chain and it clearly says canceled, when it clearly says we agree to reschedule until the document discovery is done, to then turn around and be like, and I don't even think counsel thinks it's fair. What does it matter? And B, not his problem.
He was available for a deposition. He sat for a deposition in this case. And secondly, Judge,
with no document discovery.
If you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take.
Your Honor,
We're,
let's not have anybody find out more. Make the order and let them figure it out.
I'm confident that the initial step would be reaching the staff judge advocate and informing them person to person of the status of the situation. I've left that information in my messages, but I haven't been able to reach anybody, and I will continue to do that if that's the court's recommendation.
You might not want to use the words, the other side canceled the deposition. Maybe couch it in terms that it's disputed.
It is disputed, and that's our position. Thank you, Judge.
You asked at the end of the last hearing what other motions were coming to you. There's one that relates to Mr. Matt. Well, I think Mr. Maddie's representing them, but the other individuals.
He's not jumping up.
Yeah, I know. I don't want to. Well, he's representing some of them in the defamation case.
Yeah,
I don't want to hesitate.
I don't want to take too many liberties with the court's involvement.
Yeah. I was trying to be careful, but we've got deposition notices and a motion to compel for Brian Higgins. Not Brian Higgins. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, that's coming to you very shortly. We discussed that earlier. Separately, we had a deposition scheduled of Lieutenant Brian Tully of the Mass State Police. We served Lieutenant Tully with a subpoena May 5th, and it sought documents June 1st and June 11th, so we did a better job with the service. His counsel asked to reschedule for July 8th. We rescheduled. And then the day after our hearing last week here, we got a motion to quash asking the court to say he doesn't have to show up at all, doesn't have to produce any documents. Came out of the blue. They didn't confer with us. We don't know why there would be a change when.
So much information just happened. I hate to be critical of the court, but if you keep extending the deadlines and not holding anybody's feet to it, this is where we end up.
We accommodated the date so that we served an opposition to that motion the same day we got it, which was last Thursday. And we urged them to please file it with this court as soon as we can. I don't believe that's happened based on the docket, but I just wanted to give you a heads up that is on its way.
Contrary to public belief, I have other cases that have depositions too. Personally, I don't, just for the record, to be clear, I don't want to convince the U.S. Army of anything. But the plaintiffs have forthcoming motions to compel Aidan Kearney, as well as further answers to interrogatories from Miss Reed.
Which has been ongoing.
I believe the opposition was just served the end of last week. I have been out of the office Friday and today, so I believe that both will be filed either tomorrow or Wednesday.
So what is now on the line? A motion to compel responses from Aidan Kearney, a motion to compel further responses from Karen Reed, which has been ongoing, motions to compel everyone else who we just listed. It seems like everyone but Higgins at this point.
And the plaintiffs have some concerns to date. We have submitted 53 requests for documents to Ms. Reed. 34 of those were met with objections for attorney-client privilege and work product. I do not have any privilege logs to date, nor do I have what I believe to be compliance with Superior Court Rule 30A that states the documents that are being withheld due to that specific objection. That being said, Ms. Reed is scheduled to offer deposition testimony on Wednesday of this week, less than 48 hours from now.
Tomorrow.
The first testimony she's given to date.
So
my clients are at an extreme distance.
So the problem that Reed's attorneys are complaining about as to others is now also what Reed's attorneys have not turned over, which is the privilege log.
Advantage because I anticipate forthcoming motion practice as to those objections, but without knowing what's withheld, I can't pursue the additional motion practice to put in front of this court to determine whether or not that privilege upholds.
This issue, Mr. Buck and I discussed right for the first time at the beginning of the last hearing last week on Thursday. As I told Mr. Buck, we agree we're going to get them the information that's required by Rule 30A. We're working on it right now. We're already working on it when Mr. Buck asked me first on Thursday, and we will get it to them. This is the first I'm hearing of an issue tied to the upcoming deposition. I will talk to the people that are doing it right now and try to get that to
Rosenberg. On the other side of this, if the documents aren't turned over, why would you think that it wouldn't be an issue for deposition?
them before that deposition. But they have, obviously, they'll decide how to handle that at their deposition.
Maybe remind them that if you're going to make such an objection, you're supposed to provide the privilege log, not something you work on after you make the objection. Probably not going to complete the deposition in a day anyways, right?
I don't anticipate that the likelihood of that is very high.
Certainly with other parties too.
Yeah, I just wanted to confirm that you had requested that I review the link, and I've done that. And as we sit here, my preliminary review shows that I received responsive documents to 3 of my 16 requests. So I anticipate further motion practice and at a later date. But you requested that I look at everything, and I did.
So we have finished the hearing on the motion to compel documents and deposition of Colin Albert. The attorneys have updated the court on the status of future motions to compel, and there's a bunch of them. We have heard that Karen Reed is supposed to sit for her deposition on Wednesday, June 24th. And working from the end of the hearing backwards, there is a motion to compel Karen Reed that is still outstanding. Karen Reed's team has argued that that motion to compel is moot, and they have turned over responsive documents. Attorney Buck for the plaintiffs, who is so much easier to follow for plaintiffs' counsel, and I think would probably be better in front of a jury, but maybe it's just because Diller, after the first 2 hearings, has just rubbed me the wrong way with the clickbait soliloquy and the I'm never deleting this email nonsense. But Attorney Buck was like, look, I know they say it's moot. It's not moot. Yes, they've turned over some responsive documents. However, there were also documents that were withheld for various types of privilege. Those withheld documents have not yet been identified in a privilege log. We need to have that. Rosenberg's like, well, we haven't talked about that yet, but we know that we need to turn it over and we're going to try to get it to them by Wednesday, but I don't know if we'll get it. And then the court's like, okay, well, this shouldn't be a problem for deposition, right? Because Karen Reed's deposition is going to be multiple days. And so the court was already kind of signaling that the court is not inclined to delay Karen Reed's deposition because there are multiple parties taking Karen Reed's deposition, and it will probably be a multi-day deposition because it's not just the plaintiffs. It's the plaintiffs and the 2 hospitality defendants, C.F. McCarthy's and the Waterfall. So there are multiple parties that will want to take Karen Reed's deposition in this. And to follow up on the question, Emily, what about the witness third parties that are suing Karen Reed in other litigation? No. Those parties are not a part of this deposition. These depositions are for the plaintiffs in this case and the defendants in this case. Does it mean they're not going to subpoena them in the other cases? No, they'll subpoena them in the other cases. But do they get to sit in and ask questions? No, not in this one. So it is plaintiffs' counsel, C.F. McCarthy's, and the Waterfall, and Karen Reed. That was regarding the outstanding plaintiff's motion to compel. We still have an ongoing motion to compel with Colin Albert, where the court ended up with subpoenas need to mean something, attorney's words need to mean something. I think the court has very clearly signaled that he does not think that the subpoenas expired because it was a canceled deposition. It seems to me pretty clear that the court is of the mind that that deposition was rescheduled. And the court signaled that a couple times in this, though has not made an official ruling because the court got through the round and round and round and round and round and round of the attorney arguments and then said, it sounds like we need more information about how to get Colin Albert here. So they're going to follow up on that July 6th. And then Rosenberg's like, one other thing, Your Honor, for Ms. Reed, we also got a motion to quash a subpoena for third-party witness Tully out of nowhere. And that's going to be filed on the docket. And Tully's deposition is scheduled for July 8th, and now they're trying to quash the subpoena for his deposition. So we're going to need to deal with that. And we're going to need to deal with the fact that we are bringing motions to compel not just Colin Albert, Brian Albert, Nicole Albert, Matt McCabe, and Jen McCabe. And that harkens back to the hearing a few weeks ago where counsel was like, at 10:20 this evening, I got an email from the same lawyer that's Colin Albert's lawyer saying, oh, by the way, these parties aren't available for their depositions and all of these depositions need to be rescheduled to the very end of July. So there is going to be seemingly fulsome and protracted motion practice on motions to compel all of these depositions. The civil litigation is not going to slow down anytime soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.